Good afternoon. Attorney Sean Gellis here. I take complex legal concepts and break them down into easy to understand sound bites. I'm grinding on a Saturday, decided to come outside, take a couple minutes, get some fresh air. And while I'm out here, I'm going to attempt to explain a civil litigation case to you, a whole trial from start to finish in under 3 minutes. Wish me luck. All right. So it begins with a complaint. A complaint is a document whereby one party is alleging things against another party. Usually you have to put in who the parties are, the allegations, and what it's about. So if it's like a breach of contract case, it would be a complaint for a breach of contract. Let's say we'll go ahead and use that. You go ahead and file that. You then serve the other side. That is the person that you're suing. That person has the right to file a motion to dismiss. A motion to dismiss is a motion that tests the sufficiency of the pleading. It looks at the document and says, if everything was true, would this case move forward? Here's an example of one that wouldn't work. If someone filed a lawsuit saying you punched them so hard that they flew to the moon, landed on the surface of the moon, and then flew back to Earth, that would probably be dismissed. Why? Because it's impossible. So after that, the motion to dismiss stage is heard. Your case may or may not be dismissed, and the plaintiff can amend the allegations, and that means, rewrite them to make them sufficient. Once you get through that stage, the person who's being sued, the defendant, files an answer. The answer is where you admit or deny every single paragraph, and you have the opportunity to write affirmative defenses. Affirmative defenses are things like where you would say, essentially, confess and avoid. They're defenses that say, like, yeah, well, even if this is all true, I'm not liable for this reason. Once the answer is filed, you then have a complaint and an answer. So there's allegations and denials of the allegations. Discovery then begins. Discovery is the process where both parties exchange all their evidence between each other in an attempt to make sure we have open and fair, transparent litigation. There's 3 forms of discovery primarily, plus depositions. The 3 are interrogatories, which are written questions under oath. They write questions and they send them to you. You have to write down written, sworn answers under oath and respond. There's admissions. Admissions are where they request that you admit things, like admit your name is John, admit you live at this place, whatever. You admit them or deny them. Then you have requests for production. Production requests are where the party can say, hey, here's some evidence, or give me all the documents you have about this thing. I want all the evidence that you have or documents, and you have to produce those documents. Now, throughout this process, there may be some disputes, what's relevant, what's not. Those are discovery disputes. Assuming that all goes well, there's also depositions usually after the discovery and the documents have been exchanged. You sit down under oath and you have some depositions. At the end of the depositions, all the evidence is pretty much out. Everybody pretty much has a handle on what the other person has, right? Then they file this thing called summary judgment. It's kind of a complicated concept. The test is whether there are no disputed issues of material fact and the movement is entitled to judgment as a matter of law. Looks like I ran over the 3 minutes, but we're almost done, guys. So summary judgment is really, what it really is the judge takes a look at all the evidence from both sides and says, could a reasonable jury find for this party? So if I move for summary judgment and I say I should win, and the other side says, no, you shouldn't win, the judge can look at all the evidence and say, I don't think any jury on earth could find for the defendant. And I think under the law and under all these facts that the person who filed the summary judgment motion is entitled to win. And if that happens, you get summary judgment and the case is over. Now, if there's a disputed issue of fact or if there's a dispute about the law, you will not get summary judgment, and then you will go to trial. Now, before trial, you have various pre-trial motions. The 2 most common, I'd say, are a motion in limine. A motion in limine is a motion to limit evidence at trial, meaning, if the other side is going to try to say some horrible thing about you or bring up some character flaw that you don't think is admissible, you can ask the judge in advance, Judge, keep this out. Order them before the trial that they can't even talk about this. It would be too prejudicial. And the last one I mentioned was a Daubert motion, which is a term of art. But a Daubert motion is a motion to exclude expert testimony in the case on the basis that the testimony is not sufficiently based on scientific principles, processes, etc. Essentially, the Daubert motion and the Daubert test keeps out junk science expert opinions. It would prevent a guy from coming in and giving some crazed opinion that the moon beams can affect your brain in a way that makes you commit murder and it's not your fault. That would probably fail a Daubert test because it's not based on any scientific evidence. So after all that is done, after everything's said and done, all the parties know everything, everybody knows what's going to be said and what can't be said and all that, you go to trial. So the jury, you guys on the jury, you think that it looks like it's all new to you. I'll put it this way. The lawyers know what's going to happen. The attorneys know everything. The judge knows everything. Everybody knows what all the evidence says. The judge has already read all the motions, the evidence, and already decided there wasn't enough to rule. But believe me, they understand what's going on in the case. So while if you're ever on a jury, you may think there's these TV moments where some witness storms in out of nowhere and everybody goes, and there's some bombshell, highly unlikely. All the witnesses have already been deposed. Everybody's already gave their statements. Everybody's testified. All the documents are exchanged. If somebody tried to come in on the day of trial with some new piece of evidence they've been sitting on the whole time, it would be excluded. That's the whole point of discovery and all of that. So I hope somebody may have found this informative. I'm happy to do follow-ups, but looks like I'm going to come in just under 6 minutes. But that is pretty much the civil litigation process in a nutshell from start to finish. I hope somebody finds this helpful. Like and follow for more legal wisdom.